welcome to today's webinar organized by Consulegis with 4 members on a very, I would say, hot topic because now we're about to have a new legal framework on AI, and that will be the first one. So today our webinar is called EU AI Act Impact. Your business game plan is now. If 2023 was generative AI's breakout year, 2024 will be the year of these technologies will prove their value, but also the year there will be a legal framework at first, for the first time, and giving what I will call the marketing terminology, a legal definition for maybe responsible innovation. So let me explain you. I'm Caroline Chetril, the Managing Director of Consulegis. I'm very pleased to see many Consulegis members, but also non-Consulegis members. So that's why I'm going to explain in 1 second or 1 minute what Consulegis is. For those who doesn't know what Consulegis is a leading global network connecting around 90 mid-sized independent law firms, accounting and tax firms, but also in-house, because we also have in-house as members of our international network with an international focus all across more than 40 countries worldwide. For over 30 years, our strong, stable community has given rise to countless strategy collaborations and referrals, facilitated the sharing of the best cross-border expertise, allowed our members to consistently provide exceptional services to the clients. And an example of this is our webinar today. We have four members from 4 countries, but I'm going to hand over to continue to our moderator, Bart van de Brader, for a member in Belgium Serious Legal. He's the founder and managing partner of that firm and a big specialist in IP and IT. So Bart, I'll let you continue.
Thank you, Caroline. Welcome, everybody. I will indeed try to moderate this afternoon's debate or presentation. We have 3 magnificent speakers. I wouldn't dare to add something to what they have on the wait for you. What I will try to do is give a short introduction to today's webinar, and also from a practical perspective. Caroline hasn't mentioned yet, but if you have any questions, do drop them in the chat. While the speakers are doing their thing, I will try to keep one eye on the chat, and if any of your questions can be asked to the speakers during or immediately after their presentation, I will do so. If we can't ask the question immediately, I will try to do it at the end of the webinar if we have enough time. And if we can't give you an answer at the end of the webinar, we will get back to you by mail if you make sure that we can get in touch with you afterwards. All right. We have 1 hour, and I should be in charge or in control of the slides now. That is me. I will not present myself. That is very boring for everybody in the presentation. But 2023 has been the breakthrough year of generative AI, as Caroline said, and AI in general, artificial intelligence in general, has been on the rise for the past few years. We see a strong rise in 2023, 2024 in AI tools and applications that are launched commercially on the market. And whenever there is new technology, whenever there is something new in the economy in general, lawyers always pay close attention, because usually there are legal implications as well. And that is also the case here today. What we see in AI is that there are a lot of legal challenges, issues that need to be addressed before you start working with AI. And what we don't want to do today, I think, is discourage you. I've done a number of presentations for company owners, managers in company, decision makers that decide on the adoption of AI within a company. And very often, after the lawyer has done his talk, they are very depressed and discouraged, and they think that AI is very dangerous and they shouldn't get started. That is not what we want to do today. We'll try to keep everything in a positive perspective, but do know that there are some questions. And there are a lot of questions. In fact, so many that we decided to do 2 webinars. We are having one today on one specific topic, which is the AI Act that is going or that the EU is going to give birth to in just a few weeks. But you should know that there are a lot of other legal, as I said, challenges or issues that need to be addressed before you start working with AI within your company. We will address some of them, or maybe all of them, in that second webinar that we will be hosting on the 4th of June. Unless I am very much mistaken. The invitations, the agenda, the speakers, and the topics will be on the Consolidations website and on all of our social media in a very short time, in a few weeks. So if you are, after today, you are interested to know more about the legal impact of AI, do keep a close eye on our websites and the website of Consolidations to know more about the things you see on the screen. What we've seen over the past year is a lot of issues related to intellectual property. There's a great number of lawsuits pending all over the world, in US, in China, in Japan, a few in Europe, but not as much for the time being, on the impact that AI has on intellectual property rights in 2 ways. One of the questions is content generated by AI, is it protected by copyright law? That is one. And 2, does content that is generated by AI, by generative AI tools that create text or images, is it violating existing copyrights because it is trained on existing content? 2 questions that are important, specifically for the media, the marketing industry, and anybody working with created content. There are a lot of questions around the protection of your know-how. We will get into that. Perhaps I would like to go into that in the second webinar. There are a lot of issues concerning data protection. As soon as you start using AI to process personal data in the sense of within the EU, the GDPR, there are a lot of questions that arise. There are a lot of challenges from the perspective of cybersecurity. All of those we will address later. What we will focus on today is the question of liability. And just to give you one example, there's one picture in the slide, which on the left you see a wolf, and on the right you see a husky, 2 animals that look very much alike, but are completely different. And they symbolize, if you wish, one of the liability issues that AI can provoke. AI, artificial intelligence, the name is very misleading, I think, because artificial intelligence is not quite as intelligent as we would all like it to be. Artificial intelligence, in most cases, is an algorithm that is trained or that is meant to recognize patterns. And an easy way to make that understandable to a broader audience is to use pictures, the pattern in a picture. If you want to learn an AI algorithm to see the difference between a wolf and a husky, you need to train it. And we as humans, if we have seen one wolf, we will recognize a wolf. If we have seen one husky, we will recognize the husky. That's not how AI works. If you want an AI algorithm to recognize a wolf or to distinguish a wolf from a husky, you need to train it with thousands and thousands and thousands of pictures of wolves and husky. And it will guess. Every time it sees a picture, it will guess. I think it's a wolf. I think it's a husky. And it needs validation. Either it needs approval. Yes, you are right. Good, good boy. Well done. You recognized the wolf. Or it needs to be corrected. No, you said it was a wolf, but it was in fact a husky. And it will learn from its mistakes, try again, run the same set of pictures again and again and again until it gets them right. And how does it get them right? By looking for patterns in the pictures that it is shown. Not the way we do as humans. We look at the general picture, we try to distinguish some characteristics of a wolf or a husky and base our decision on that. That is not how AI works. And what you see here is a classic example where thousands and thousands and thousands of pictures are used to train an algorithm to see the difference between a wolf and a husky. And then when the researchers think that the algorithm is ready, it can distinguish the wolf from the husky, the AI is deployed. And the first picture it is shown, it says, this is a wolf. oh, sorry, this is a husky, and it's wrong. It made a mistake. And then searchers start to wonder, how is this possible? It was trained the way it should have been trained. It was doing very good in the training sessions. And now we deploy the AI and it gets it wrong. And then they start looking, where did things go wrong? And it turns out that it went wrong because the AI is looking for patterns. And patterns for us are, for instance, the eyes of a husky. A husky has a blue eye and a black eye, or blue eye and a brown eye. That is how we would recognize the husky. But in fact, the AI looks at the entire picture. And then it turns out that every time a picture of a husky was used during the training of the AI, that husky was standing in the snow. And every time a picture of a wolf was used during the training of the AI, the wolf was standing in a forest or in a field. And what the AI learned over time was not to recognize a wolf or a husky, it was to recognize a pattern in the picture. And the pattern was white background, was snow. That is what the AI learned. And that is how AI works. And that brings risks because AI can be wrong. AI can be biased. AI can take decisions that are not the decision that we wanted to take because the training process that we as humans don't understand and don't control. All we can do is show it pictures and say you were right or you were wrong in the decision that you took. That will bring risks because replace the wolf and the husky by, for instance, a mold on your skin and try to train the algorithm to recognize skin cancer. The risk is that it makes the same type of mistake. And actually it has. There is an app on the market, or that was launched 2 years ago, that was meant to recognize skin cancer. And it was trained and it was good and it could recognize, it could say this mold is a skin cancer and this mold isn't, until it was deployed and used commercially. And then it turned out that it was wrong very often. And it didn't turn up false positives. It didn't say this is a skin cancer, why? Well, it wasn't. It turned up false negatives. It said this is not a skin cancer, while in fact it was. And then they start trying to understand why the AI was wrong. And it turns out that it was fed with pictures of skin cancers. And if doctors use a picture of a skin cancer, it has a measuring tape next to it to see how big the mold is. And what the AI learned was not the shape and the color and the size of the mold. It was, oh, there's a measuring tape in the picture, so it has to be a skin cancer. So those type of things go wrong. The EU understood that a long, long time ago. And they've been working on what is now the EU, or what is going to be the EU Act that we're going to discuss today. Now, very short, because I don't want to take time away from the speakers. Very short. Most of you, if you are following this webinar, you know what the AI Act is going to be. But in a very short summary, this is going to be the first comprehensive legal framework in the world that wants to regulate the use, the development, the sale, the distribution, the import, all aspects of AI. And what we want to do is the same thing that we did with GDPR a few years ago. We want to introduce what the EU calls a risk-based approach. We want to estimate the level of risk involved with a certain AI, and we want to, depending on the level of risk that is involved, we want to add consequences to that level of risk. And what we want to do is, we make 4 categories. We want people to do risk assessments to know where they stand, and depending on the level, they will have obligations like registering with the authorities, guaranteeing transparency. Jos will come back to that in short. And then, and I will already mention that now, there are 4 categories, but the most important category will be the category of absolutely forbidden AI. There are applications that we want to avoid. Everybody has seen the doom scenarios where AI, artificial intelligence, is going to take over the world, which is not going to happen because artificial intelligence is not as intelligent as we think it to be, but we want to avoid that. So we have created an absolutely forbidden category of AI. And what we see is the same as what we've seen with GDPR or with the DSA, DMA legislations that have come from the EU, the Digital Markets Act, that has come from the EU. That is very, very, very high fines. And what is interesting here, and we will discuss it in the end of the presentation with Anne-Marie, is that we want to regulate all use of AI as soon as it is put on the market in the EU, or as soon as it is used to process data belonging to EU citizens. So it has a very broad scope that goes beyond the borders of the AI. Now, you may have seen on LinkedIn or on other social media a bunch of people saying that the AI has been finally approved. We want to nuance that. The AI Act has not been published yet. The European Parliament has approved, the European Commission has approved, the Council is on the way of approval, and then it will be published normally in a few weeks. And we will see in the course of Jos's presentation a timeline. But basically speaking, the text will be there this spring, and then between 2025 and 2027, all aspects of the AI Act will go into action. We will go into that in the first presentation. We have 3 presentations today by a very expert panel that is going to try not to make you panic, but take panic away from you, and explain what the impact of the AI Act is going to be. We have 3 speakers. The first is Jos from BG Legal in the Netherlands, who is going to talk to us about risk assessments under the AI Act. What are categories of risks? What are risk assessments? How are companies impacted? What do you have to do? How do you have to prepare to start working with AI within your company? After that, Isabelle from Paris is going to talk to us about general purpose AI systems. She's going to explain to us what is the difference between AI in general and general purpose AI, and why is that difference so important? How is that regulated, and what is the impact on companies? And in the end of the session, Anne-Marie is going to give us her perspective as a non-EU lawyer from Great Britain. And we are going to discuss the impact the AI Act is going to have on companies outside of the EU or on organizations outside of the EU. That is enough from me. I will pass the mic to Jos. I will keep one eye on the chat, like I said. If you have any questions, do post them over there. Well, Jos, the floor is yours.
Thank you, Bart, for the introduction. Let me see whether I can share the... Yes, that's working. Okay, thank you for the introduction. You already mentioned risks and AI. In March 2021, the European Commission presented the Digital Decade 2030, which is a guide for the digital transformation of Europe that has resulted in a lot of new EU regulation. You already mentioned some of that, the GDPR, of course, cyber resilience, data governance, and of course the AI Act. The AI Act introduces a risk-based approach and introduces a classification of AI systems based on use cases and based on the level of impact of these use cases. The AI Act identifies 4 categories from unacceptable risks, which are prohibited, high risk, limited risk, and minimal risk. And I will go into this further in this presentation. Risk is related to harm to health, safety, or fundamental rights. And each risk category has its own set of obligations. The classification of general purpose AI models is based on high impact capabilities and significant impact due to reach, and Isabelle will elaborate on that topic. In the picture on the right, you can see the relationship between the AI risk categories and AI models. And the AI Act is product safety regulation, and that means that an AI system that is conform the EU regulation has to have a CE mark, as shown in the left of this slide, and it will have to have a declaration of conformity. It is important to know that the AI Act identifies roles in the AI value chain, and each role has its own set of obligations. Most of the obligations are for the provider of the AI system. For instance, that results in obligations like assessing whether the AI system is compliant with the AI Act. Providers have to have a quality management system. providers and deployers have to avoid the deployment, development, or marketing of the prohibited AI systems. And because of the different set of obligations, depending on the role in the AI value chain, each party has to determine what is their role in the AI value chain and what are the obligations of that role. And also good to bear in mind that a party can have different roles in the AI value chain. For example, someone can be both provider and distributor of an AI system. The first category is the unacceptable risk AI systems. This is for AI practices that have unacceptable risks, and these AI systems are prohibited. This means that development or marketing of these AI systems is prohibited in the EU, and the AI Act gives a list of prohibited AI practices. And one of the practices the AI Act mentions is emotion recognition in the workplace and educational institutions. On this slide, you will see two examples. And the left one is a school in China where the children have a device on their head, and the device makes it possible that the teacher can follow the students and gets a signal when the student is not paying attention, is not awake, sleeping. That is a prohibited AI system. On the right, you see an AI system that is used in a truck or in a car, and it follows the emotions of the driver, and it is trained to see whether the driver is sleeping, and that is because it's used for that purpose. That is an allowed system. And the consequence of the unacceptable, the prohibited AI system is that they have to be off the EU market probably by the end of the year, but that depends on when on the timeline of the AI system, of the AI Act, and I will come to that in a moment. Then the high-risk AI systems. There are two types of high-risk AI systems. The first one is the what we call the Annex 2 high-risk AI systems. That are AI systems that are integrated in products that are already regulated. Examples are medical devices, lifts, and toys. And then we have the Annex 3 AI systems. The Annex 3 has a list of areas that are regarded as high risk, such as AI systems used as safety components of critical infrastructure, and AI systems used for job candidate selection. And the list, the Annex 3, can be adjusted in time. That means that when the conclusion is that an AI system is not as high risk as originally thought, then they can be removed from the list, and it can be a new areas or new AI systems can be added to the list. There is an escape, and the escape is that when the provider proves that there is no significant risk of harm to health, safety, or fundamental rights of natural persons. So the AI system is based on Annex 2 or Annex 3, a high-risk AI system, but when the provider can prove that there is no significant risk, then it doesn't have to comply with all the obligations, all the requirements of a high-risk AI system. The consequence of a high-risk AI system is that it has to conduct a conformity assessment, and it has to be registered in a register for high-risk AI systems. As I mentioned, there are requirements for these high-risk AI systems, all mentioned in the AI Act, and that are so there's a list of requirements, and that are requirements like having and maintaining a risk management system, record keeping, data governance, technical documentation, cybersecurity, robustness and accuracy, transparency, and human oversight. So these requirements are mentioned in the AI Act. And there's also a requirement to conduct a conformity assessment. What the conformity assessment is also mentioned in one of the annexes to the AI Act. Public bodies also have to conduct a fundamental rights impact assessment when they are about or planning to use a high-risk AI system. These requirements that are mentioned in the AI Act are quite vague. For instance, Article 14 about human oversight, it says high-risk AI systems shall be designed and developed in such a way that they can be effectively overseen by natural persons during the period in which the AI system is in use. But what does it mean? How do you have to do that? How do you have to comply with that? Now, the European Commission has seen that, and therefore they have asked the European standardization organizations, CEN-CENELEC, to develop European standards for these requirements. And these standards that are now being developed will make it more easy to audit and assess compliance with these requirements. Then there's the category of medium and low risk AI systems. The recitals of the AI Act give some examples of medium and low risk AI systems. And two examples are of medium risk deepfake and chatbots. And the obligation is that you have to be transparent. So you have to mention, to disclose that deepfake is used, or you have to disclose that someone is interacting with a chatbot. So transparency. And for the low risk, the AI Act mentioned the establishment of codes of conduct by the industry for those low risk AI systems. Then I come to how to prepare for the AI Act. It starts with investigating whether your organization is using AI systems and what kind of AI systems. You have to map the AI systems. And when you are using AI systems or AI models, you have to assess the risks involved with using those AI systems. And when there are risks involved, try to mitigate them. That's an instrument for doing that is an AI risk assessment. And of course, when you're using prohibited AI systems, you have to stop using them before the end of the year. And the identification of a prohibited AI system can be the result of, for instance, the AI mapping. When you are using or developing high-risk AI systems, you have to assess compliance with the requirements of the AI Act. The instrument to do that is the AI compliance assessment. And as I mentioned, the AI Act gives some indications how what a compliance assessment would look like. When your employees are using AI tools such as ChatGPT, it is wise to give rules to your employees on how and when they can use them. An instrument for that is the AI policy. I also advise to when you're using AI systems to check your insurance. Are you sufficiently insured for using AI systems? When you are a member of a board of directors or a supervisory board of an organization that is developing or using AI, you have to be aware of the risks that using the AI in your organization offers, and it is wise to have training or an awareness session on that topic. And as I mentioned, when you are a public body using high-risk AI systems, you have to perform an fundamental rights and algorithm impact assessment. Then I come to I mentioned the AI mapping. What are you doing when you are AI mapping? You're using starting point the use case of the AI system. You establish, you determine what is the risk level of that AI system, and according to the classification, you check whether the obligations of that risk category are met in your organization, or if not, what to do to fix it. This is the AI timeline. As I mentioned, the starting point is the publication of the AI Act. As Bart already mentioned, we expect the publication in a few weeks' time, May, June, and that's the starting point of this timeline. 6 months after the publication, all prohibited AI systems have to be off the EU market. We expect by the end of this year. 18 months later, all the Annex 3 high-risk AI systems have to comply with the requirements of the AI Act. And 36 months later, the Annex 2 high-risk AI systems have to comply with the AI Act. And then I come to my final slide. How can we help you? We share information that can help you to understand the AI Act, to assess compliance with the AI Act, like documents, flowcharts, online checklists that can help you in assessing your position and compliance. And of course, we can assist you when you're drafting documents like an AI policy, or we can guide you when you're conducting an AI risk assessment or an AI conformity assessment. And finally, we are part of Consulegis, the IT data protection group of Consulegis. And that means that we can not only advise you on the EU regulation, but we can also advise you on the additional national legislation. Because we have members in different countries, we can advise you on the aspects in that particular country that you're interested in. That's the end of my presentation. Thank you.
Thank you, Jos. I've seen a few questions. Weirdly enough, people are sending questions just to me and not in open chat. Don't be afraid, people, to share your questions with everybody. We don't have a lot of time because I want to make sure that Isabel and Anne-Marie have enough time to give their presentation. So just one little question, one that was already in my mind as well, that I wanted to ask you, but I see that people are asking the same question. We see that there are 4 different levels of risks in the EU Act. In the AI Act, but what is a risk? What are the factors that I have to take into account to determine that there is a high risk? A high risk for what or for who? What determines the level of risk involved with an AI application or tool or model? I already gave one example, I think, in the introduction when it comes to possible bias or wrong decisions. But is there anything else that helps you determine that this is high risk or this is low risk, or what is the danger in AI? Let me rephrase it like that.
Thank you, Bart. Well, that's an interesting question. I'm a member of the standardization committee that is developing these standards. And this is a question in that committee too. What is risk? Because risk in the AI Act, it is defined in the recitals, but it's slightly different than risk, the definition of risk, for instance, in the GDPR. But the recitals of the AI Act give us an indication of how to interpret risk related to the risk categories. So, and that's also what in an AI risk assessment. We would look at the recitals, how it is defined in the recitals, or see how the standardization committees give a concrete way of determining the risk. It's quite vague, but there will have to be concrete examples The use cases will be very important for determining, is this a high risk or is this forbidden? So it will be partly based on the recitals and part on the use cases that will be become public, and guidelines from the European from the AI board or that's coming. So we have to wait for concrete text on that, but for now we have to do it with the recitals of the AI Act.
Thank you, Jos. I see that one of the participants already mentioned that the AI Act itself defines what is the risk. That was, of course, the answer I was looking for by asking the question. But thank you, Marianne, for pointing it out as well. All right, let's move on because time goes fast. Isabel, general purpose AI. What can you learn us about GPAI? Unmute yourself, please.
Thank you very much, Bart, for introducing my topics. GPAI models have been very famous over the last 12 months, and the Commission and the EU Parliament and Council have to react very quickly in order to properly take into account this new technology. There are a couple of GPAI models which are very powerful, and they are edited by either Google with BERT, by Microsoft, by OpenAI, obviously, with GPT, by Facebook, by Mistral, a French company. So there are a couple of very active actors, and they have been able to make up a very incredible application in AI because they are capable of generating human-like content across a wide range of tasks, such as including language translation, text summarization, question answering, video, image, generated computer coding. So what they're capable of doing is absolutely wide and likely to create risk, particularly because they are training with large amount of data, as you mentioned in your introduction. They're capable to perform a very wide range of distinct tasks, as I just mentioned, and they are integrated into a variety of downstream system and application. Generally speaking, they are not working as a standalone product. They are integrated into applications. And due to their very high level of adaptability and their learning capability, they really deserve special precaution. And it's very clear that GPAI models could be integrated in application, which could then be qualified as high-risk system and then be subject to specific applicable rules as detailed by Jos. So there are a cumulative application of rules. We are going now to address just a specific rule of a GPAI model, but there are some other rules which could also apply. It's great opportunity because it increases productivity, it enrich human creativity, it's new resources for communication, training, education. But in the meantime, it creates a whole range of new risks. It can borrow the voice or image of third party. It can create a fraud, a risk of fraud by misusing identity or create fake website. The biased risk is very often mentioned, and that could amplify discrimination, which is very critical, particularly in the hiring procedure. There is a risk of error and hallucination when the prompts are not properly given or the results are just wrong. And there is a real risk of attrition and cultural depletion through reinforcement of existing opinion and possible lack of training of critical thinking by users. So we have to take into account that the way those very powerful tools will be put on the market in 12 months' time is first by information and transparency along the value chain in order to help to mitigate the risk associated with the artificially generated content. So the picture of the Pope here will still be allowed, but it have to be mentioned as being generated by computer. And that obligation applied to the producer, the provider of the AI model, but then the deployer of the AI model will have to also to comply with a similar obligation when its model create deepfake or information to the public on matter of public interest. And in particular, in our upcoming year of democratic election, this issue of information to the public on matter of public interest is really critical. So another obligation, another way to obtain a protection of general interest is obligation to draft technical documentation. The provider of such model have to draft technical documentation in great detail. They have to indicate the task of the model it intends to perform, the architecture, the number of parameters, the technical means required to integrate the model into a system, information on data training, testing, and validation. So it's just an example of the whole list that documentation will have to provide, and it will have to be made available to the AI office on request or to the integrator of the GPAI model. This obligation does not apply when the model is accessible under a free and open license, because then those information are already available. Another way, another aspect of protecting people and the whole economy is a focus on copyright law, because those models have to train on very extensive data, and some of them are protected by copyright. And the outcome of those models also may therefore use copyrighted material. So the way to take care of this very significant issue has been the opt-out option for copyright holders. Therefore, the copyright holders can put an opt-out in a machine-readable form on the machine, which is having the information, the copyright content. And in such a case, such content cannot be retrieved for GPAI training. But this mechanism does not yet embrace all practical situations where copyright is involved, because the standard still have to be developed and to be widespread in a market. So we still have to wait a little bit before this requirement is really becoming effective. But the whole people involved work on this very important requirements. Before going to the systemic risk, just one final requirement on general obligation for GPAI model is the obligation to publish the way the model has been trained. And the AI office will adopt a template to identify such information. So again, information precise and concrete information still has to come and to be determined by people working on implementation of the rules. Another aspect of the of this AI model is that some of them are creating systemic risk because they are so powerful that they have a high impact capabilities. And I was told that ChatGPT 4 will have high impact capabilities. And therefore, we have to increase again the way to mitigate risk in order to have those products available on the market. Mitigation of risk will be focused on risk which relate to public health, safety, public security, and fundamental rights. In order to mitigate those very significant risks, additional technical documentation will have to be drafted. They will have to maintain an adequate cybersecurity protection. The conduct model evaluation, including adversarial testing, will have to be undertaken, and report to the Commission will have to be made when serious incidents will occur. So again, it's a matter of mitigate the risk for such very powerful tools. With respect to those tools, code of practice are very, very important because GPAI are very recent on the market. They are highly innovative, and evolutionary nature of those tools requires very flexible, scalable rules based on feedback from the field. And consequently, it has to be focused and it has to be really, we have to keep in mind that the whole bunch of rules applicable to such tools are not yet established and will have to be made in the upcoming 12 months. In addition to the code of practice, the code of conduct shall facilitate the effective implementation of the obligation of transparency and labeling. The AI office will adopt the template to identify content on information used to train AI model. So keep in mind, keep your eyes open on all those very upcoming significant and important guideline and soft law in order to better understand how those rules are going to apply. I just to keep the time to and to leave sufficient time to Anne-Marie, I will not get into all the detail of those slides regarding how to implement those rules because they are very similar to the one addressed by Joss. But what I want to tell you is that soft law is very important. We know how to work with soft law because we did that for GDPR, and we are sure that the law will be flexible and very applicable to the matter of hand. And I don't think that in Europe we regulate too much and we don't innovate enough. I think we are ready to be in complete adequation with the people who are innovating and using AI in Europe. Thank you.
Thank you, Isabelle. I will not go into questions so that Anne-Marie has enough time to give her presentation. There is one interesting question from Troy. Troy, don't worry. I will try to ask your question at the end of Anne-Marie's presentation. I think it's a question that's more for Jos than for Isabelle, but we will get back to you. But first, let's listen to Anne-Marie Blake. Anne-Marie, you are a lawyer in the UK. Your clients are outside of the EU. How do they look at this new EU AI Act, and how do you think it's going to impact them outside of the EU?
Thanks, Bart, for the introduction. Hi, everyone. As Bart said, I'm going to talk to you about why the Act matters for those of us who are outside the EU. And Bart, Jos and Isabel have already given us a detailed overview of the Act, which, as I've said, promises to establish the most extensive AI regulatory framework globally. Now, those of us outside the EU might be scratching their heads and wondering, what's the big deal if you're not based in the EU? Well, technology and the internet don't stop at the borders of the EU, and there's a couple of reasons why you should pay attention to the Act and why it might matter to you. First off, EU regulations tend to have a knack for spreading their influence beyond the borders of the EU. Think about the GDPR, for example. Its influence on privacy standards went global within a couple of years. You've had tech giants like Meta and Microsoft who have changed how they operate worldwide to become compliant with the GDPR. So when the EU makes a move like this, it's worth taking notice. Secondly, the Act itself doesn't just affect EU businesses. It reaches beyond EU borders, and it's going to encompass companies that are dealing with AI products that are used in Europe. So even if your business isn't physically located in the EU, if you're dealing with businesses there, if you're selling AI products or even just using AI systems whose results end up in the EU, well, guess what? You're going to be in the Act's crosshairs as well. But before we talk about why businesses outside of the EU need to be cognizant of the Act, let's talk about the timeline for implementation. I know Bart and Jos have already discussed that. And as Bart said, the Act isn't law yet. There's a few steps that need to happen before it is going to become law. It's going to undergo a final lawyer linguist check, expected to happen in the next few weeks. Then the European Council will provide a formal endorsement. And then sometime, probably in April or May, the Act will be published in the official journal of the EU. And then 20 days after that publication, it comes into effect. But even then, there's going to be a period of about 2 years, so likely April to June 2026, before it comes into full effect. And that sounds a long way off, and you probably think you've got plenty of time to prepare. But I know, and I suspect Bart, Jos, and Isabel also know from experience that it's not a lot of time at all. The GDPR, for example, was adopted in 2016, came into effect in May 2018. And the businesses that did the best were those who had spent time beforehand mapping out their data flows, working out what personal data they held, and getting compliant. And there were plenty of organizations trying to play catch up who hadn't taken the time before the GDPR came into effect to ensure they were compliant with it. So what I would urge you to do is start getting compliant as soon as possible and get advice if needed. So let's turn first to the precedent of EU legislation having an impact outside the borders of the EU. And it's what's known as the Brussels effect. And it's a phenomenon that was first coined by Anu Bradford back in 2012. And what it refers to is the EU's unilateral superpower to regulate global markets. So in other words, it's the global impact of European legislation in other parts of the world. It's like a ripple effect where EU regulations set the standards worldwide. And we've seen this happen before. The EU's already had an impact on globally in areas such as consumer health and safety, environmental protection, antitrust laws, and online hate speech. And I think probably most of you are aware of the GDPR. And that's inspired privacy laws in over 100 countries, 20 of which are very closely modelled on the GDPR. And this Act is poised to potentially have a similar effect by influencing AI regulations in other jurisdictions. And in contrast to how superpowers will wield their global influence, the Brussels effect means the EU doesn't have to play a direct role in imposing standards, because market forces alone will usually be sufficient, because multinational companies will voluntarily extend these rules to their global operations. And commentators have already been looking at the likely Brussels effect of the Act. And what they've concluded is that AI systems and regulated products will be significantly affected around the world. And that's particularly the case for high-risk AI that's built into online or otherwise internationally interconnected platforms. And you know from what Jos said earlier that high-risk AI systems are the ones that are going to be subject to the most onerous requirements of the Act. But as well as the high-risk systems, commentators are also seeing that transparency requirements for AI that interacts with humans, so chatbots, emotion detection systems, etc., they're expecting that that will lead to global disclosure on most websites and apps. But as well as the Brussels effect, the Act itself does provide for extraterritorial reach. And we know from what Jos has said, the Act covers the whole value chain of stakeholders. So that's your providers, your manufacturers, importers, representatives, deployers, and distributors of AI systems. And those stakeholders aren't just organisations based in the EU, because Article 2 extends the application of the Act to organisations outside the EU. And the relevant articles, if you want to look at them, are Articles 2(1)(a) and (c). And what they say is regulation applies to providers placing on the market or putting into service AI systems or placing on the market general purpose AI models in the Union, irrespective of whether those providers are established or located in the Union or a third country, and to providers and deployers of AI systems that have their place of establishment or who are located in a third country where the output produced by the systems used in the Union. And there's a few limited exceptions to Article 2 that I won't go into in any depth, but generally they relate to research and testing before systems are placed on the market, or to systems developed for the sole purpose of scientific research and discovery, or free and open source systems, except where there be a prohibited or high-risk system. So unless one of those exceptions applies, if your business is placing, making available, or putting into service an AI system in the EU market, or if you're going to make outputs produced by an AI product available in the EU, then your organisation is going to be caught by the Act. So understanding what the Act and what you need to do to be compliant is going to be crucial both for businesses in the EU and outside. So let's look at some examples. So you're a tech innovator based in Silicon Valley. You've just developed a cutting-edge AI system. You want to sell it in Europe. Your company hasn't got an office there. You're going to be able to sell it, but your US-based entity is going to need to comply with the rules that are set out in the AI Act. And that's because what you're doing, you're placing or making available your system in the EU, hence it's coming within the scope of the Act. Let's say you're a pension fund in Tokyo, you've got an AI system that analyzes data, you want to share that with your partner organization in Paris. Both of you in this case are going to need to ensure that you're compliant with the Act when your Paris partner uses the insights. And that's because you're making the outputs produced by your system available in the EU. So what does coming within the scope of the Act mean for your organisation? Well, as Bart said, there's some pretty significant penalties for breaches. So you'll be in line for those if your business breaches the Act. And we're talking about fines and penalties of 7% of global turnover, or potentially millions of euros in penalties. So it's critical, therefore, that non-EU organisations that are deploying developing or offering AI-driven solutions in the EU consider how and to what extent the Act's going to apply to them. Now, as well as being aware of the penalties, you also need to be aware, if you're outside of the EU, that providers of high-risk systems that are established outside of the EU, where an importer can't be identified, must appoint an authorised representative, and that authorised representative needs to be appointed prior to you making your systems available on the market and by written mandate. Now, I've had a look in the last few days and I can't see anyone offering that service yet, but I expect by the time the Act comes into effect, there'll be plenty of organisations who are offering that service. So if your business comes within the scope of the Act, you're going to need to ensure that your internal processes, procedures, and broader compliance environments allow for compliance with the Act. First, get clued up on where your AI is going and what rules apply. Is the territorial reach of your AI products going to extend to the EU? If so, seek out some expert advice on what steps you need to take to stay on the right side of the law. And as Jos said, you're consulegis, we're an international organisation, there's going to be someone in your jurisdiction who can advise you on the AI Act. So, in conclusion, as Jos has said as well, map your systems, have an AI policy, prepare compliance and risk assessments, undertake AI training, adjust or renegotiate your contracts if you need to. All of this is very similar to the steps that organisations needed to take to become GDPR compliant. So a lot of you are probably familiar with those sorts of steps already. And while the Act might feel like a steep hill to climb, there's no time like the present to start that ascent, especially with global AI regulation shifting at a rapid pace. I think for businesses, wherever they're based, if they're looking to do business globally involving AI systems, it's going to become more and more difficult to escape coming within the scope of regulation as more countries globally look to regulate AI. So therefore, businesses that take the initiative now to comply with the Act are going to be well placed to meet the challenges of future AI regulation. Thank you very much, everyone.
Thank you, Anne-Marie. I understand from what I've read and from what you've told us in the preparation of this webinar as well, that the approach of the UK government to AI is very different from the approach in the EU. They've chosen a different position in relation to AI. In relation to that, there is a question from Charles, who is asking us if there is a UK equivalence to the AI Act and if you foresee one in the near future. So maybe you could tell us in a few words how the UK is approaching the phenomenon of AI.
Yeah, the UK has taken a very different approach to the EU. So rather than regulate in the same way that the EU has, what the UK has done is very principles-based approach. And instead, it's relying on the laws it already has in place and the regulators in place to regulate the system that way, but without a new landscape. What it's looking to do is to try and attract global innovation and businesses to the UK. And I think what's going to be interesting in the long term is how that works as more and more countries, we've got the EU AI Act coming in, Brazil's looking to regulate, and it will be introducing its act soon, I think, which is similar to the EU AI Act. China's regulating AI, the US is as well. So as more and more countries globally start to regulate, businesses, I think, are going to find it difficult to stay outside the scope of global regulation.
Is that something that may lead to the same issue as the one we also see with, for instance, GDPR, where there's so many different frameworks that are all more or less comparable? You mentioned Brazil, for instance, which has legislation very close to GDPR, but not quite the same. Is that going to create the same issue for companies that want to work on a global scale, where they have to take into account 10, 15, 20, 25 different legal frameworks that are all slightly different?
I think it probably is. And I think what you tend to find with GDPR is that many organizations that are dealing globally will ensure that they're GDPR compliant, which tends to mean that they are compliant with most other privacy laws worldwide, maybe with a few tweaks here and there. So I expect we'll probably see organizations looking to comply with the EU AI Act, and then tweaking as necessary for any particular variances with other jurisdictions.
We'll wait and see.
We will indeed.
Jos, I see that the question raised by Troy earlier has gotten 3 thumbs up so far. So apparently a question that everybody wants to ask. Maybe we should jump to that one. The question by Troy is a question that I also had on my list for you. How will the EU AI Act affect the use of AI for use within an enterprise as a tool for business intelligence, for instance? Supply chain optimization. AI data will come from within the enterprise, and the use of the AI outputs will be used to optimize business processes. That sounds to me like something that is going to be low risk, but maybe you can confirm. And then it also relates to another question that I had. That is, you talked about the value chain, the entire chain between the developer and the end user, and the need to position yourself to know where you are in that chain. I think that a lot of people participating today are potential users of AI within their company, potentially towards end users outside of the company. How much of what we've discussed today is directly relevant for them or to them, or are the main responsibilities with developers and distributors?
Your first question, what kind of risk category will probably be suitable for this kind of application? I think, as you mentioned, probably low risk, although someone correctly mentioned low risk is not defined in the AI Act, but it is in the recitals mentioned. But this kind of application, I don't think it will be prohibited or high risk. But the AI Act deals with, is about the use of AI systems. So also the use internal of an AI system. There is one exception for research and educational organizations, the research exception. They can use, for instance, prohibited AI systems in their research environment. But this kind of application, again, probably low risk, but also for internal use, the AI Act is applicable.
Okay, I just want to add something to answer this question. I understand that actually a GPI model will be put at the disposal of this enterprise. And then, as we see together, we saw that together, the providers of such a GPAI model will assume most of the obligation of compliance with the AI Act. And the users, the enterprise, will have to check the license by which he has access to the GPAI models in order to make sure the providers and the deployers of the model does not exclude its liability and does not exclude warranty on the way the model is performing or whether the model is in compliance with the law. I think such exclusion of warranty and liability wouldn't be lawful. They would be against public order. However, that would involve a discussion, likely in court, and it's more wise to prevent such discussion in court and to negotiate the agreement and the license by which the user is going to have access to this GPAI model which will be inserted into its own computer and system.
Thank you, Isabel. Troy, to add a final comment from my side to your question, even if, and we are going to skip the because we're running out of time, huh? But even if an AI, as you describe it, that is purely internal business intelligence, even if it would be very low risk, it will still bring with it a number of risks, maybe not for the outside world and maybe not for people's data being used or processed, or it may not affect the broader public, but it will bring about a number of risks for your company. A few of the risks that I discussed in the beginning of the webinar. We don't have time today to dive into those. All we can say today is that even if what you think you're going to do is very low risk, you still need to map the AI you're going to use. You still need to know what data is going to be processed. You still need to know who your partners are. You still need good contracts that will cover liability issues if things go wrong. All of that are topics that we hope to address in a second session that is coming up in June, of which we are still trying to put together the agenda, the most relevant subjects or topics to be addressed. We are finalizing that. We are going to put that up on the Consilegas websites very soon. So if you are considering starting to use AI within your company in the very near future, maybe you should also follow the second webinar, where we will try to be more hands-on and practical and give you advice that you can take with you and use within your organization when you're starting to the prospection and the decision-making process that will eventually lead to the use of AI within your organization. I see that about 80% of the participants that we started with are still in the webinar. Thank you for sticking around. I also see that it's 6:15 Central European time, and we were supposed to end this around 6, so we are already 50 minutes overdue. So unless there are any questions that somebody wants to ask, and if you want to do so, please let us know, then we can share the mic. But unless there's any more questions, we will slowly, I think, work our way towards the end of this session. Does anybody wish to add anything, or does anybody have a question? Do raise your hand. I see Isabel has raised her hand, so we will give the word to Isabel. Isabel?
Actually, that was in relation with my previous comment. So
Okay.
no final word, but thank you so much to anyone and to everyone. And thank you, Bart, for introducing this hot topic.
Thank you all for sharing your wisdom with us. I see no further questions for the moment. So thank you to our speakers. Thank you to Consilegas for organizing this. I see in the chat that Caroline has also mentioned that the recording will be available afterwards, so you can look back. Thank you all for your time, and we hope to see you again in June for the next session.